No, they already stole all that.
Yeah, that's true. You know, if you read this bicycle case, you know, the example that I was telling you about where we had the contempt, you really ought to go and look at that first amended action. All right, now what that was about was that this guy was riding his bicycle and somebody came through, stopped at a stop sign, and then started up again and hit him, causing $50,000 to $100,000 in medical injuries. Okay? So you wanted to collect. Well, it turns out under state codes, and by the way, this was a minor who was a licensed driver, legitimate, okay, it was very fine, but the codes say that a minor who gets in an accident has a limited liability of $15,000. It also says that the parent of the minor has a limited liability of $15,000. And it also says that the aggregate total of minor's liability plus parent's liability is limited to $15,000. And they had a $15,000 insurance policy. Well, that's fine. We were happy with that. But what we did is we said, well, the state of California licensed this person. What's a license? A license is a partnership. Okay? A license is taking responsibility for the quality of the product that's involved here. In other words, how good does she drive? There's no question it was her fault. Okay? And there's many court rulings that have said that the state loses its limited liability protection when it is engaged in commerce. It now becomes like any other company. Okay? So what we said is, well, let's take a look at this. And by the way, a lot of my writing might look good to you, but it's plagiarized. I lifted it out of court decisions. Okay? So when we get to the end point, we can bring in these courts and say, well, here's the accusation and here's what the court said. Here's another accusation, here's what the court said. This is a perfect match. That case applies. State loses. But anyway, we went through all that, and basically, the theory that we have is that the state has a vicarious liability. In other words, it has, not only does it, you see, if the state just passed the rules of the road, there would be no liability, because the state's not a participant. They said, here's the rules and that's it. But the state maintains a quality control force out there called traffic cops. Okay? And if your quality of driving drops below a certain pre-designated level as measured by the number of tickets you get and the type of tickets you get, well, then they take away your license, right? So you have quality control. So they're involved. They're involved in training programs. They're involved in advertising. They're part of the commerce. So what we said is, well, hey, we don't care if the state has a $15,000 limited liability here. What we have here is a third-party intervener. And we don't care how much they protect this person as long as they're willing to make up the difference. Okay? So we're suing for $2 million. We've settled out of court with the original participants, leaving California holding the bag. All right? Now, the state of California could come back and sue them, but obviously I don't think they would do that. You know, these people didn't have anything anyway. And we're not after them. We weren't trying to make life miserable for them. It's just an accident, okay? But, I mean, it had serious consequences. But why should... You see, here's the concept. You know, you always hear about these limited liability rules and suits and this sort of thing. Well, here's what's going on. Is they're saying that the tortfeasor, the one who does wrong, shouldn't have to pay more than X amount. Well, I agree with that concept, excepting for one thing. If they don't pay, who does? Well, I'll tell you who does. It's the person who got injured. He makes up the difference. So, you got $100,000 in medical bills. You got some $15,000 get paid by the tortfeasor. 15 from 100,000 comes out $85,000 is what the victim pays. Is that fair? No. Well, under common law, you know, there's always a remedy. Well, with common law, you can make up a remedy if you can't find one. All right? So, we've got here a heavy participant in the commerce. So the state's going to be, we have yet to write the judgment. That's our next step. We've reached that stage where I'm going to write the judgment. This should be interesting. But the case here that's on here. This is the case. It's on the computer. It's a very, it's got everything you need. Go ahead.
You could sue the state if an insurance company didn't pay for injuries that somebody sustained in an accident.
Well, I wouldn't do that. I think, don't they have a fund that protects against bad insurance companies? You know, they go out of business or something, or there's a fund like that. I would attack the fund. And the other thing is that there's another issue that you need to look at before you consider that anyway, and that's the bad faith element. Okay? There's a guy who really developed the bad faith element. It happened right in Los Angeles. All right, there was a lawsuit, and just look up bad faith on FindLaw. I'm sure you'll find cases related to that. But you, in good faith, pay your premiums. Why? Because you expect if you have a problem, you've got the promise to be covered. Well, what happens when the insurance company doesn't keep that promise, right? They took your money. You have no way to check until the day it happened. Well, this guy had something happen, and he put in an insurance claim, and I think it was something like $15 or $20 or $30. I don't know, somewhere there, real small claim. And this insurance company just really messed with him. And he was black, and they have a policy, no blacks get paid. Okay? And they actually, through discovery, found company memos that came out and said that. All right? So, they crucified this insurance company for bad faith. So the claim was $15 to $30, but the payoff was $2 million. Okay? Something to hurt the company because of the bad faith. It sounds like you have a bad faith claim.
It's an insurance company in New York.
Well, they're operating in California. They've got a contract. They have a license with California. If you have it, if you're doing, I don't know, I'm assuming that. I'm assuming a lot.
My mom was in an accident where somebody...
In New York.
In New York.
Well, I don't know what they've done.
She had a claim against Geico.
Yeah, well, I don't know what goes on in New York, but I...
She got injured. She hasn't been compensated.
Well, I don't know what goes on in New York, but I suspect that the case law that's developed out of California in bad faith would be applicable there.
Excellent. Well, the only thing is they have some kind of some kind of no-fault deal going on in New York, which makes it hard to get around in the...
Well, whatever it is, you know, you gotta look at these angles. I don't have enough information to really give you an answer. Okay.
But they badgered her. I mean,
oh yeah, well they're going to do that, and I mean, and public agencies are used to protect insurance interests. We've seen that a lot too, especially in the medical business. Doctors putting claims in for insurance for their patients, and then they go after the doctor's license. You know, they've been known to do that. We do that a lot in Wisconsin.
Now I got a question for going back after them.
Lobby. Okay. What else do we have here? What are you interested in?
Yeah.
Don't let me get too far off track. You came here for a purpose. I'm pretty well talked out on the subject because. Oh well, we have more about motions, don't we? Make a motion? Well, it's 8:45, I think. Yeah. We're supposed to quit at 9. That's when they officially close here. Here we go. I don't know what the status of the DVDs is.
20 more minutes?
15 to 20 minutes.
All right.
We're going to mail it to you for CD.
Okay. Basically, the organization on this...
Been moved and seconded to record of record.
Okay. Any discussion? Any discussion? Oh, here you are.
Yeah, with the demurrer and the moving for summary judgment. Okay, so you file as a plaintiff, right? And then you said the attorney comes back with a demurrer.
Right.
Okay, and then so that comes back, and then your best move is to ask for a summary judgment.
No, well, yeah, that's true. But before you do, you need to clean up the lawsuit. So all the legal things that he objected to, as much as possible, agree to him that he is right, that your lawsuit is wrong, and agree to throw that out.
Right.
But you want to leave enough, because that is what he does agree to.
Right.
And often they slip up. They do this, okay? They don't cover all the points. They just cover things they think they're going to win on, except they don't expect you to make that move. They expect you to argue, see? But what you do is you don't argue. Instead, you say, yep, that's wrong, that's wrong, that's wrong. You clean it all out.
Yeah.
What's left? All the facts he agreed to and the few laws that he didn't object to. Right. And you apply the law, that's it, done deal.
Okay, and so then you win. Now, does he have the opportunity to ask for a summary judgment before you do?
Yeah, he does, and you say, great.
Oh, still you say great. Okay.
Yeah, you say, because what's left? When you agree to dismiss the charges from the lawsuit, all the things you said he did wrong, and you come down to what's left.
Right.
Now, you're not going to crash your case. I mean, if you agree to everything, you have no case, right?
Right. Yeah.
But you try to find the things that he failed to object to. Okay?
What if you covered all the bases?
Well, if you covered all the bases, you better use another strategy. But I'm saying they usually make mistakes, okay? They usually don't cover all the bases. They just pick highlights. Because remember, has anybody here put together a lawsuit? Nobody. You got people here who's never done a lawsuit?
I've been sued, yeah.
Either way. Okay? You must have some feel about how difficult it is to compose them and to organize it, right? It's not easy. Well, look, those guys have the same problem. Well, they have a formula they follow, but when you throw a kicker in there, they don't know what to do. Okay? They have the same problem. And you see, and you're honed in on some of these issues that all this sovereignty stuff is new to them.
They don't have a clue.
They don't have a clue. They don't have a sense of perspective like you will have.
They don't know how to deal with that statute.
That's exactly.
No, they can't make it.
That's right. So, yeah, but what you do is you kind of, assuming that you have, that they've done something, they're not going to hit all the bases. They'll probably make mistakes. If they made the mistakes, take advantage of them. If they didn't make any mistakes, think of a new strategy. Maybe that's not the best one. See, maybe you can come back and say, okay, I'll revise it. And then usually the court says, yeah, okay, plaintiff has agreed that it's defective, and plaintiff will file an amended lawsuit, fixing these problems. And so you do fix them. Okay?
So, Bill, what happens if the court shines you on completely?
Well, you're the court. Why would you shine yourself on?
No, I'm not talking about your court. I'm talking about their court.
Well, their court doesn't talk because you just took jurisdiction away from them because you did a counterclaim, right?
Do they know that, though?
Well, you explain it in your paperwork. You have your case law. There's plenty of case law that says that when you do a counterclaim, their action stops.
My experience is the judge runs his own court the way he wants to. Period.
Well, have you ever issued an order against the judge?
No, I haven't.
Well, maybe that's why he keeps going. Look at this sample case that's on this CD when you get it, or go to the website. It's on there. You can just, okay, look at that. Because that's exactly what happened. We issued an order to the judge, and he went moving on later with another order. Well, we didn't just lay down and say, well, what do you do? No, what we did is we issued an order back, found him in contempt, and fined him. Okay? And if you want to know how to do that, study the lawsuit. It's there. We went through all the bases, we tried to make this a perfect case, okay? This case has been 5 years in the making. It could have been shorter, but we wanted it to be a show place, and we thought through all the reasoning process, plugged all the holes we could find, and so forth. So you really do have a good model. And if you study that and you learn it and you discuss it among yourselves, you're going to find that everything is in there that absolutely strips the judge of his authority and puts the authority in your hand to find him in contempt.
Which particular case?
Yeah, it's the one that's called Example. Okay? Yeah. 1215.org. That's the website. It's the one that's called Example on there. The Example. How many times have I clicked on Example to show you something? Yeah, about 3 or 4 times. Yeah.
Now, if you're going to do a counterclaim,
Yeah.
is it titled a counterclaim?
Sure.
Yes.
Okay, so it's called...
But understand it's only a title. That does not control. What
That's
controls is the body.
Now,
Just the other day, I filed a case that was a counterclaim, and the clerks got all excited. So I said, no problem, we'll change it to complaint. Didn't affect the body. It only affected the title. Now they were happy and they filed it. Okay? Don't worry about it.
all right. Do you have an example of a counterclaim? Is that, or is
A
this
counterclaim is identical to an original claim. The only difference is that you did it second instead of first.
All right.
Okay? All the same wording, but you give it that label, counterclaim, and then what is the issue? Number one issue in any counterclaim. What is it? That's it. You got it. Jurisdiction. So challenge jurisdiction. Why jurisdiction and not some other? Why?
Because nothing else happens without jurisdiction.
You shut down their case until they prove the jurisdiction to your court. Okay? That's why you pick jurisdiction. There's many things you can sue for, but that's your flagship item. That's what you go after on jurisdiction, so that they have to stop their case. They cannot proceed until they prove jurisdiction. Got lots of case law to support you on that, so use it.
Now, when you're building it, you have, again, the two boxes on the left-hand side, and you are listed as the counterclaimant.
Yeah.
And that one down below.
Right.
Correct?
Or, well, the other guy was. That was,
They would
I
be-
sued first and they sued second.
Right.
But that wasn't a counterclaim. That was a countersuit.
No, but I'm just saying, that is how you would do it.
Yeah,
You would
that's
be
the
listed
form.
as the defendant up
Right.
here and the counterclaimant down
Right,
here.
that's why I put on there, to show the
Yeah.
form.
Okay.
Sure.
After jurisdiction, then you've got damages?
Well, yeah, you have injuries because they exceeded jurisdiction.
Right.
It affected your rights or whatever. So now you suffered an injury. Now you place a value on the injury. That value is called damages.
Right.
The word damages means money.
Okay.
Okay? Damage does not mean injury. Damage means the money that the injury is worth that you want to collect.
And then after that, you go to your points and authorities?
Well, yeah, you decree the law if you're talking about a lawsuit. You say the law of the case is blah, blah, blah. And you look at this First Amendment action. That was done correctly.
What do you do to,
You know, the judge is going to want to take control right from the beginning, so what do you do to disqualify him or put him in his place?
Well, first of all, you filed the lawsuit, didn't you?
Yeah.
That disqualified him. Did you say in your lawsuit that you're one of the people of California and in this court of record complain of?
Yeah.
Well, that did it. In the court of record, is the tribunal independent of the magistrate?
Yeah, but there's...
Well, there you are. You suspended the judge as far as... Okay?
But then they'll, like you were giving an example of how they
The first
will
time
rule anyway.
Look, the first
sometimes.
time you're in court, he won't know it. He'll read your papers exactly the way all the attorneys read it. Say, oh yeah, people, yeah, all right, court of record. He'll say, people, yeah, court of record, okay. So he buzzes through that. Everybody knows the court of record keeps a record of the proceedings and has the power to fine and jail for contempt. They don't know the other three requirements. They look it up in Black's Law Dictionary, 5th, 6th, 7th, or maybe now 8th edition. Okay? What do they see? Court of record. Oh yeah, has the power to fine contempt and keeps a record of the proceedings. That's all they know. That's policy. That's all they want them to know. So then they fly off at the handle. They do all this sort of stuff. Well then, the first court session is never going to go your way because they don't know. Even though you put it in front of their eyes, they still don't know. So it's when they do something and all you do is you don't argue. Whatever they do that you don't like, you just say, I object. Why do you object? Well, it's not my wish. Now I'm speaking as a plaintiff, okay? Okay? If that's the best you can do, you're overruled. Well, for the record, I do object. Okay, noted. Noted in the record. Moving on. Next issue. Whatever it is, I object. Okay, same conversation. If there's enough of them, he says, yeah, I know, you object to everything. Well, thank you. Now I don't have to say object anymore, see? As long as it's on the record. So you object to everything. Well, the thing is that's only for the time you're in the courtroom, and that makes it real efficient. You know, it costs money to get transcripts. Okay, transcripts can get very expensive. But my transcripts are only 5 minutes long. I typically pay $30, $40 for a transcript instead of $150 or $200, okay? And then what I do is I sit down, I write my order, vacating the judge's decision, explaining in my order, and you have an example, and this example has all that in it. And I explain the judge, I'm one of the people, the sovereignty, the whole thing, it's all there. You got a chain of logic. It's logically arranged so that one thought leads to the next, so you don't have holes in it, all right? You have the preamble. The Constitution says the people, ordain and establish the Constitution. The people are relative. I don't know what people are, but I know that relative to the government, they're boss, okay? Because we ordain and establish it. And so you just go down through that chain of logic, and in your order, and then you say, because of all this, the judge has no authority to overrule the sovereignty of the case, and so you vacate his order. You order it out. And then when he reads it, that's when he gets educated. And if you want to know whether or not this works, on this example case that's on the CD, and you don't have to wait for the CD because it's on the website, 1215.org. You go to that website and you click on the example and you read the transcripts. It tells you how the judge reacted the next time we met him, okay, in court. And it's fun. He stutters, he stammers, he's trying to collect his thoughts. The attorney's there saying, well, Your Honor, is that an order? And the judge saying, well, it's all in the paperwork, okay? I mean, really, you look at that, you compare the very first transcript. It's kind of mild. The judge was fairly, I'd say reasonably friendly for a judge, okay? But no question about it, he has a position of being in charge. That's his attitude in the first transcript. Then he makes his order. Then we reverse his order. And then we have another hearing of some kind, whatever it was. You read that second transcript, there's a whole different attitude base that he has. Completely different. Because he knows he's been had.
Do you submit the order on the first day?
We don't submit. We submit it whenever we get through writing it.
Well, I mean, when you go in the first day, he's mild, you say, or he could be a kind of
Hey, look, the question is, does he submit the order?
When?
Well, no, we don't submit. What happens is that the judge issues the order. You leave the courtroom.
Okay.
All right? With the court reporter, you order a transcript. She gives you the transcript.
Okay.
Okay? Then you sit down, you analyze it. Huh? Well, he's not talking, I'm talking.
No, me. He wants me to use the mic.
Yeah, but you're not talking, I was.
I know.
Okay, so,
I'm using it.
Okay, yeah, all right. But look, you get the transcript, you analyze it. It might take you a month to come back with the order vacating his order.
Okay.
All right? I mean, you do it sensibly.
Okay.
Yeah, you don't let this thing rush you.
I just wonder how prepared you have to be for these things.
Prepared enough to be able to sit down and study it and analyze it. There's no time limit on this.
Okay.
By the way, I want to inform you that the court moves at its own speed. Those time requirements are only for the litigants. When the court makes a decision, the sovereign of the court, and issues a court order out of the court against the judge, that's whenever you're ready. But I've saved you a lot of time, okay? You've been saved a lot of time and a lot of work because on this example, we've got a lot of the writing already done. You can lift it off and just plug it in. All right? You cannot lift it off and plug it in blindly. It's got to make sense. But I've saved you a lot of work now. Okay? So anyway, feel free to use it. That's why I put it there. We've done a tremendous amount of work on this, and we've had fun with it.
Who's we?
Well, it's not my case, actually. I wrote all the papers, okay, but it's our case.
You're working with an attorney.
I am?
No, I don't know.
We're working with a client.
Client. What they call it, client. Okay.
No, I have no clients. Okay?
Oh, yeah, no client.
No.
He's working with one of the people.
All right, this guy, he got injured on a bicycle. Okay? So he's suing. And then we had all this, but we're working together. Yeah, it's a team effort. Sure. And this guy was shrewd. The victim was shrewd. He said, I got all the time in the world to do it right. He says, he was in accord with me. The reason I agreed to help him was because he was of the same mind. We're going to produce something that people can use as an example. That's always the question. The question everybody asks me eventually, somewhere along the line, one way or another, is, did the judge go along with that? Okay? Well, read the transcript and decide for yourself whether or not he went along with it. It's fun reading at some points. Okay? Yes, he went along with it. Why? Because we were solid. All right? We didn't just issue an order saying, hey, we outrank you. No. We put in some real case law, some real statutory law, which he could look at, and although I'm not subject to it, he is. He takes an oath of office that subjects him. Okay? He has to respect it. And he said so. He said he had to follow the California rules. Well, great. We're glad to know that. That's why we convicted him under California rules. Okay? No, it's not a precedent because precedents only come out of the appellate courts and the Supreme Courts. And this is when you're in a sovereign court, you're not in the system. You're out of the system. A common law court is a court outside the Constitution. The Constitution acknowledges the existence. If you look at Article 3, Section 2 of the United States Constitution, it says the judicial power of the United States is available in all cases in law and equity. So if it arises under the Constitution, but we sue outside the Constitution, okay? Because I'm one of the people. I'm up above. I'm one of the creators of the country, or I'm in that class. So as that class of human being, I decree my own law. You see, the other side can ask for a jury, and if they ask for a jury, one of the jobs of the jury is to determine the validity of my law. That's why you have jury nullification. See, I can make it illegal by my law for anybody to wear pink shoes in my presence. And if anybody does wear pink shoes in my presence, it's a death penalty, okay? I mean, this really affects me. It torques me out. All right? So if somebody does, I can bring charges against them. Now, what do you think the probability is that we can gather up a jury if the defendant wants a jury, and I suspect he will, considering he wouldn't trust me as a tribunal. All right? But if he were to ask for a jury, what do you think the probability is that the jury would think that my law is reasonable? Okay? Pretty close to zero. But take the other situation. Walking along the street, minding your own business, somebody comes out of nowhere and plows me in the eye and gives me a nice shiner. Okay? I didn't even know who he was. I didn't talk to him. I didn't even look at him. It just came out of nowhere. And then I decree, my law is that he should go to jail for 30 days for assault or for battery. Okay? And if he does that and he asks for a jury, what do you think the jury would do? You think they'd convict him?
Give me a year.
Well, whatever, but the point is that, you see, this is the great genius of the common law system, is its custom and usage. And if you make your lawsuit in line with custom and usage, you will get the backing of the jury, because that's what they believe. But if you don't, then you won't. Okay? Okay? Minutes or seconds?
Minutes.
Okay. So, the common law is a great leveler of fraud and all the other problems of courts. And so that I believe in it, obviously. Any other quickie questions? We're running out of minutes. All right, I guess we're going to break up. All right. One more. Quickie.
It's a read thing. With the Black's Law, you said the fourth edition addresses common law, and the fifth edition...
It's stripped out, right. Fourth edition and earlier is real law. Fifth edition and later is policy.
Okay.
Okay? And so that's I like to have both, because I want to know what the attorneys are supposed to know according to the power structure, and then I want to know what the real law is. And I also use Bouvier's Law Dictionary, which I don't know if there's still reprints of it at America's Bookstore in Sacramento. But you could check there. They used to sell Bouvier's Law Dictionary for $80. I think they raised it to $120 now. And so, there we are. Okay, I think we're out of...
Store on La Palma also.
Oh yeah, in La Palma. Do they have reprints?
I don't know. If
No, this was done by the bookstore in Sacramento, specifically.
And fourth edition, Black's Law?
Well, you gotta hunt through the used bookstores for that one.
They're available.